This is continuation of our discussion on the basic principles. As regards the scope of taxation, our code is COPS. It is said to be comprehensive, unlimited, plenary, and supreme. As a general rule, the power to tax is an incident of sovereignty and is unlimited in its range, acknowledging in its very nature no limits, so that the security against it is to be found only in the responsibility of legislature, which imposes the tax. As held by the Supreme Court in the case of Chu versus Videogram Regulatory Board, the power to tax is so unlimited in force and so searching in extent that courts scarcely venture to declare that it is subject to any restrictions whatsoever, except such as rest in the discretion of the authority. Now, this emanates from the lifeblood theory, because the government cannot exist without taxes, without revenues to support or finance its operations. The principles that flow from the lifeblood theory presumes that it is unlimited and plenary power. That there's this presumption that tax laws are valid. That is a presumption. And the right to collect taxes is imprescriptible unless there is a law that provides for prescription. The collection of taxes may not be enjoined by injunction. Courts cannot interfere. Courts cannot issue temporary restraining order or preliminary injunction with respect to collection of taxes. And taxes could not be the subject of compensation or set-off. That may apply in case of ordinary obligations. But with respect to taxes, the rule is that it cannot be subject of compensation or set-off. It is very easy, and basically, the reason is lifeblood theory. However, even if it is so searching in extent, that the power of taxation is so searching in extent, another justice countered the dictum of Chief Justice Marshall. Justice Holmes said, "The power to tax does not involve the power to destroy while this court sits." And that is the reason why we have the limitations. Subject to limitations, and the limitations in our jurisdiction may either be inherent limitations or constitutional limitations. Remember, class, that the power to tax is unlimited and plenary. It is very comprehensive in such a way that Congress has the leeway and discretion to tax whoever and whatever subjects of taxation. Basically because the government needs funds to finance itself, its operations. Now, however, the dictums of Justice Marshall and Justice Holmes can be reconciled. The power to tax involves the power to destroy. The power to tax does not involve the power to destroy while this court sits. Authorities reconcile these points of view, that even if taxation is very broad power, it can still be subject to limitations. If it is already arbitrary, confiscatory, or even oppressive, or it violates the limitations set forth in our Constitution as well as the inherent limitations. The tax law can be rendered nugatory or without legal effect. Question: which is the best answer? A tax reform at any given time underscores the fact that A. Taxation is inherent power of the state. Letter B. Taxation is essentially a legislative power. Letter C. Taxation is a power that is very broad. And letter D. The state can and should adopt progressive taxation. Our answer? Letter C. Taxation is a power that is very broad. That anytime Congress can make legislation subjecting a particular subject matter to tax. But of course, we will discuss the limitations, constitutional and inherent limitations. Let us discuss the limitations on the power of taxation. The limitations may either be inherent or constitutional limitations. For purposes of answering MCQs, you just memorize the inherent limitations and the rest are already considered as constitutional limitations. Our code for the inherent limitations, PINET. P-I-N-E-T. P stands for it must be for public purpose. I for international committee. N for non-delegation of the power to tax. E, exemption of government. T for territoriality. The first requirement in the inherent limitation, the requirement that the levy must be for public purpose, that the tax must be used for public purpose. Is it required that we must be directly benefited by the tax or imposition, by the proceeds of the tax or imposition? Answer is no. For as long as the government is using the proceeds of the tax for public purpose, there is this law which imposes a tax, and the proceeds of that tax shall be used in the development of the sugar industry. A taxpayer assailed the validity of the tax, saying that he is not directly benefited by the imposition, that he is not benefited by the said tax proceeds. Is the contention of the taxpayer valid or correct? Answer is no. For as long as the proceeds of the tax shall be used for public purpose, regardless of whether or not we are directly benefited, the imposition or the tax is considered as valid. In another example, the city government allotted funds, and the funds derived from the taxes that the constituents are paying, allotted funds for the construction of basketball court inside the subdivision. A constituent taxpayer assailed the validity of the disbursement of funds. How would you assail the validity of the disbursement of funds? Say that there's an ordinance allotting funds for the said project of the government, of the LGU, by filing a taxpayer's suit. By filing a taxpayer's suit. Now, is the contention of the constituent taxpayer of the LGU meritorious? Answer is yes. Because the subdivision, construction of basketball court in the subdivision, and the subdivision is limited only to its property owners. The subdivision is a private property, and that will not benefit the public. Although that will promote sports, but limited only to few, the property owners. Therefore, it is not for public purpose. Non-delegation of the power to tax. The rule is potestas delegata non delegare potest. What has been delegated cannot be delegated. Because, as we said, the power of taxation is essentially legislative. And only Congress can enact tax laws. Do we have any exception on this limitation? Yes, we have 3 exceptions. And I want you to memorize the 3 exceptions because that might be asked. The first exception, the delegation to the President, but limited authority to the President. Under Section 28, Paragraph 2 of Article 6 of our Philippine Constitution. Congress may by law authorize the President to fix within specified limits and subject to such limitations and restrictions as it may impose tariff rates, import and export quotas, tonnage and wharfage dues, and other duties or imposed within the framework of the National Development Program of the government. Well, that is too technical, ma'am. We cannot understand. The delegation to President is limited to, this is for tariff and customs, no? But limited only to specified limits, tariff rates, import and export quotas, tonnage and wharfage dues, and other duties of, or imposed. Limited to the tariff and customs under Section 28, Paragraph 2 of Article 6 of the Philippine Constitution. This will be discussed in tariff and customs in our discussion about the Bureau of Customs. I think that will be for tax 3. Another exception, the delegation to local government units. To the local governments. Under Section 5 of Article 10 of the Philippine Constitution, each local government unit shall have the power to create its own sources of revenues. That is the reason why, as to taxing authority, we classify taxes either as national or local tax. If it is imposed by the national level, the national government, then that will be national tax. If it is imposed by the local government units, that is local tax. How would we know if that is being imposed by the national or the local? It depends on where you are paying. If you are paying to accredited bank, say the accredited of the BAR or BOC or collecting agent for that matter, then that will be national. If you are paying for BIR or BOC, then that is national. If you are paying before the city treasurer or the provincial city, municipality, or even the barangay treasurer, that is local. That is local tax. Now, the delegation to the local government units, because the LGUs are given the right to create. Now, the power to create its own sources of revenues. Now, that is exception to the non-delegation of the power to tax. That is why we have national and local taxes. Another exception to the non-delegation. Now, the delegation to administrative bodies. Now, once a law has been enacted, there must be an implementing rules and regulations. And this is in the form of implementing rules and regulations. Now, we have the revenue regulations. This is the power of subordinate legislation. And in order to be valid, the delegation must be complete in itself. And the law must fix a standard. The three exceptions on the non-delegation of the power to tax, because it is essentially legislative and it is vested in Congress. The delegation to the President, the delegation to the local governments, and delegation to administrative bodies. Then next, we have exemption from taxation of government entities. This is self-explanatory because it is as if that you are getting your money from one pocket and putting it to your other pocket. And there will be no more source, there's no source of revenue to the government. The rule is agencies performing governmental functions are exempt from tax unless expressly taxed, while those performing proprietary functions are subject to tax unless exempted. Then we have international committee. What is international committee? In international law, we have respect between nations. In Latin, par in parem non habet imperium. Par in parem non habet imperium. No state can claim jurisdiction over another. Can the United States Embassy in the Philippines be required to pay real property tax by our government? Answer is no, because that will be violative of this inherent limitation. International committee. Then we have territoriality. Now, later on we will discuss situs. Sometimes they call it a situs. The place or jurisdiction of jurisdiction to tax. And that is very basic. Now, when we say territoriality, our laws are valid and can be enforced within the jurisdiction. Say, a law is passed requiring a property owner that owns real property in Canada. A law was passed here in the Philippines requiring that property owner in Canada to pay real property tax here in the Philippines. The real property is situated in Canada. However, the Philippine government imposes tax, real property tax to be specific, on that property situated in Canada. Even if the taxpayer is a Filipino, but the property is located in Canada and what is being imposed is real property tax. Would that imposition be violative of a limitation? Answer is yes. That is violative of the inherent limitation, particularly territoriality. Remember, for the inherent limitations, yeah, we have PNET, that it must be for public purpose, international committee, non-delegation of the power to tax, exemption of government from tax, and territoriality. Now let us proceed to the constitutional limitations. There's no need for you to memorize the article or the provision numbers for as long as you know the essence, no, of the constitutional provision. First, due process clause. Due process under Section 1, Article 3 of the Philippine Constitution. No person shall be deprived of life, liberty, or property without due process of law. Then there is a continuation, nor shall any person be deprived of equal protection of the law. That is for equal protection clause. Due process and equal protection of the law. Usually, if you will be assailing the validity of a law, even if it has been passed, it already passed Congress, approved by the President, if you wanted to assail its validity or constitutionality, this is one of the grounds. Now, let us apply it in taxation. If the imposition is so arbitrary, confiscatory, oppressive, unjust, to the point that it already deprives the taxpayer of his property, that would be violation of due process. Now, let us apply. Say individual income tax. It is progressive. As the tax base increases, the tax rate increases. And that is consistent with ability to pay theory. Canon. That is a canon in taxation. Now, and it ranges. It ranges from being exempt until 32%. Until 32%. And then we have 25% for the non-resident aliens not engaged in trade or business. Then the rest based on the taxable income. This we will discuss as we go along. Now, and then for corporate income taxpayers at present, it is not yet amended. But then sooner or later we will have another law lowering the tax rate. But at present we have the 30%. 30% that is proportional tax. Proportional tax rate. That means 30 to 30 is still reasonable. Congress passed a law imposing 90% tax rate to taxpayer. To the taxpayer, see, that is income tax. What will be our reaction? It is as if that we are slaves of the government, and that is too confiscatory. That is oppressive and too confiscatory, unjust. Now, can we assail the validity of the law or the imposition? Answer is yes. We can file an action to declare it as unconstitutional. On what premise? Due process. This will be our weapon to question the constitutionality of that law. Then now we have equal protection of the law. Equal protection of the law under the same provision of due process. Section 1, Article 3 of the Constitution. Now, in this case, of course, there must be a valid classification, and there must be a substantial distinction, and it must be germane to the purpose of the law. We can correlate this equal protection with uniformity and equity in taxation. The rule of taxation shall be uniform and equitable, and Congress shall evolve a progressive system of taxation, correlating it with equal protection. Under Section 28, Paragraph 1 of Article 6 of the Constitution. Now, uniformity of taxation means that all taxable persons or property of the same class shall be taxed at the uniform or same rate. There is uniformity when tax operates within the same force and effect on the same subject wherever found. You know what? There is this case of Shell versus Vano. What happened in this case? The municipality passed an ordinance imposing tax on installation managers. On installation managers. That is an occupation tax. Occupation tax is a local tax. It is not a national tax. Now, there's only one installation manager in that locality. That was questioned by the taxpayer for being unconstitutional, therefore invalid. What is the ruling there? Now, is the ordinance be considered as valid? Answer is yes. The occupation tax could be imposed on all installation managers who may come within the jurisdiction of the municipality. What the ordinance taxes is the occupation and not the person alone. Sooner or later, if there would be other installation managers, then all will be subject to this kind of occupation tax. Therefore, the ordinance is valid. No imprisonment for non-payment of poll tax. No imprisonment for non-payment of debt, for non-payment of poll tax. Poll tax, we are referring to the present. Diba? We have cedula, poll tax, then we have the community tax. If we will not be paying our community tax, and take note, the basic community tax. We will not be imprisoned. That is a constitutional limitation. But if you did not declare, because it is under oath, if you did not declare properly your occupation or your source of income, other information for your additional community tax, you may be held liable. What is contemplated by law is the poll tax, the basic community tax. No impairment of obligation of contracts. Under Section 10, Article 3 of the Constitution. No law impairing obligations of contracts shall be passed. Now, this is quite complicated. But let us just simplify. Now, the government granted exemption to, say, telecom companies. The LGU na lang. The LGU granted exemption to telecom companies. Now, subsequently thereafter, the LGU revoked the exemption. Can the telecom companies assail the revocation of the revocation of their exemption, assail the validity of the tax law because it impairs obligations of contracts? Answer is no. Answer is no. However, say the government entered into contract with a delivery or courier company, granting that courier company an exemption, but with the consideration that that courier company will deliver the mails and packages of the government, but granting exemption. Hmm? Subsequently, there's a sudden change of mind, and a law was passed revoking the exemption without the concurrence or without the consent, conformity of the courier company. Question, can the courier company taxpayer assail the validity of the law revoking its exemption? Yes. Because there is a contract between the government and the taxpayer, and that will violate, that will impair obligations of contracts. But if it is not, if it is only unilateral, that the government merely granted the exemption without any contract or consideration for that matter, government anytime can revoke the exemption. Perhaps that would be a classical example for non-impairment of obligations of contracts. This is a constitutional limitation. Then we have, this is not included in our enumeration, but non-infringement of religious freedom. No appropriation for religious purposes. Now, this is, of course, no separation of the church and the state. Then we have, this is very important, and this might be asked in the MCQs, exemption of religious, charitable or educational entities, non-profit cemeteries, and churches from what? From real property tax. Lands and buildings, as well as improvements, actually directly and exclusively used for religious, charitable, or educational purposes shall be exempt from taxation, particularly real property tax. The word exclusive means primarily rather than solely. The admission of paying patients does not detract from the charitable character of the hospital if all its funds are devoted exclusively to the maintenance of the institution as a public charity. Now, a good example for this is the Lung Center of the Philippines versus Quezon City. Now, in that case, if you will pass along Quezon Avenue Circle, you will see Quezon City Hall and the Lung Center. Because it is near Quezon City Hall, perhaps that is the reason why Quezon City, particularly the assessor, was able to notice that the entire land of Lung Center of the Philippines is exempt, previously exempt from real property tax. But it was noticed and observed by the city government. There are idle portions. We have the hospital, there are idle portions. When we say idle portions, bakante. May mga bakanteng lote. And there are portions being leased to the botanical, orchids, farm. Subsequently, the Quezon City government assess Land Center of the Philippines. For what? For real property tax. Now, saying that not all portions of the land are being used actually directly and exclusively used for charitable purposes. It was questioned by Lang Center until it reached Supreme Court. Lang Center of the Philippines is the petitioner. Is the Quezon City government correct? Yes. The answer is yes. Why? Because it is required that the property, say it's a land, the building, improvement, must be actually directly and exclusively used for religious, educational, or charitable purposes, to be given the exemption. Ownership is not it is not the requirement. What is required is use of the property. Ownership is not material. It is the use of the property. Okay, remember this class. This might be asked in the MCQs. Now, we have exemption of revenues and assets of non-stock, non-profit educational institutions and donations for educational purposes from taxation. All revenues and assets of non-stock, non-profit educational institutions used actually directly and exclusively for educational purposes shall be exempt from taxes and duties. And the coverage is not only for real property tax, income tax, other national taxes, value-added tax, business tax, as well as customs duties. Now, let us just distinguish. Non-stock, non-profit educational institutions exempt from tax. Income tax, business tax, customs duties. Exempt from tax. Non-stock, non-profit. How would we know if it is non-stock, non-profit educational institution? Remember the rule on strictissimi juris. If you are claiming for tax exemption, it is strictly construed against the taxpayer and in favor, liberally in favor of the government. Therefore, how would you prove that you are exempt? Because you are a non-stock, non-profit educational institution. Prove it to the bay, or when you register, you present your SEC and your permits. You present documentary requirements for exemption. Now, how about public educational institutions? By the way, we are only referring to educational institutions. Schools. Schools ito, schools. Unlike the exemption to real property tax, religious, charitable, educational institutions, and non-profit cemeteries, churches from taxation. Now, in this case, the exemption revenues and assets of non-stock, non-profit educational institutions. Strictly for schools. Exempt din yan for real property tax. Now, let us just limit to educational institutions. Public schools, public educational institutions, government educational institutions, exempt. But it is not by provision of the Constitution. Statutory. Under the NIRC, National Internal Revenue Code, under the law, exempt government educational institutions. What else? Government educational institutions, it is not by virtue of the Constitution. It is by statutory exemption. Pwede rin siya papasok for inherent limitation. If it is, of course, the government exclusively for government functions. Proprietary educational institutions. Ayan. The proprietary educational institutions. So what will happen to proprietary educational institutions? Subject to income tax, but at a lower rate. At present, 10%. We do not know if there would be changes. But our discussion will still be the present law. Now, proprietary educational institutions subject to income tax at a lower rate of 10% for as long as it meets the requirement. The requirement set forth under the NIRC. Now, to subject it to a lower rate. How about real property tax? How about real property tax? That will fall under the previous constitutional limitation. That will fall under Section 28, Paragraph 3 of Article 6 of the Constitution. Okay. Now, by the way, the exemption of revenues and assets of non-stock, non-profit educational institutions subject to conditions prescribed by law, all grants, endowments, donations, or contributions used actually, directly, and exclusively for educational purposes shall be exempt from tax. Under Section 4, Paragraph 3 of Article 14 of the Constitution. Okay. Now, this is not included in the outline, but with respect to the grant of tax exemption, no law granting any tax exemption shall be passed without the concurrence of majority of all members of Congress. Without the concurrence of majority of all members of Congress. This is under Section 28, Paragraph 4 of Article 6 of the Constitution. Another constitutional limitation, the President has the power to veto any particular item or items in a revenue or tariff bill. The President shall have the power to veto any particular item or items in an appropriation, revenue, or tariff bill. But the veto shall not affect the item or items to which he does not object. This is under Section 27, Paragraph 2 of Article 6 of the Constitution. And last, still not included in my presentation, in the slide, non-impairment of the jurisdiction of the Supreme Court in tax cases. The Supreme Court shall have the power to review, revise, reverse, modify, or affirm on appeal or certiorari, as the law or the rules of court may provide, final judgments and orders of lower courts in all cases involving the legality of any tax imposed, assessment or toll, or any penalty imposed in relation thereto. Following Section 5, Paragraph 2 of Article 8 of the Constitution. Now, you just remember, we have several constitutional provisions regarding the power of the state to tax, but these provisions of the Constitution are limitations and not grants of power. For purposes of the MCQs, you just memorize the inherent limitations. PINET, that it must be for public purpose, international committee, non-delegation of the power to tax, exemption of the government from tax, and territoriality. Now, the rest are already constitutional limitations.